When we hear about the horrible atrocities that plague our world today, it is easy to lose hope and to give up. Unfortunately, the Avengers don't exist, and there's no magic spell to rid the world of evil. If only there was a way that the perpetrators of these crimes could be punished. The International Criminal Court works to do just that. However, while the ICC aims to hold these criminals accountable, they are not as effective as they could be. So what is the ICC? The ICC is an intergovernmental organization set up in 2002. The main headquarters are located in The Hague, Netherlands. However, the court is authorized to convene anywhere else in the world as well. Participants include 123 countries from around the world classified as state parties, 34 states from Africa, 19 Asian and Pacific states, 18 from Eastern Europe, 27 Latin American and Caribbean states, and 25 Western European and North American states. The main goal of the ICC is to deal with three types of crime: genocide, crimes against humanity, and war crimes. In theory, the court works to hold military and political leaders accountable for these crimes. Now, what exactly is covered in those three general terms? Let's break it down. First off, genocide. In general, genocide refers to the blatant acts committed to destroy in whole or in part a national, ethnical, racial, or religious group. Such acts include killing members of the group, inflicting bodily or mental harm, preventing birth of that group, or transferring children of the group to another group. Crimes against humanity encompass a little more than both of the other categories. The general definition is an act that is committed as part of a widespread or systemic attack directed against any civilian population with knowledge of that attack. Some specific examples of these crimes are murder, extermination, enslavement, deportation, rape, torture, and apartheid. War crimes are when any grave breaches to the Geneva Convention of 1949 are committed. These acts include willful killing, torture, or taking hostages, among many other things. Currently, crimes of aggression are being considered as an added jurisdiction of the court. Crimes of aggression would include invasion, military occupation, forceful annexation, blockade of ports, or other such crimes. The expected decision date for this added jurisdiction won't be until 2017. The Rome Statute is the main document or treaty that defines these terms and the general rules, duties, and restrictions of the ICC. The court itself is made up of four parts: the presidency, which is the head of the court, the chambers, which ensure fair trials, the office of the prosecutor, which is in charge of conducting investigation and prosecutions, and the registry, which supports the court. So how does a court decide which cases to take? The process is as follows. A state may refer a situation to the prosecutor in which one or more of the crimes within the jurisdiction of the court appear to have been committed. The ICC only prosecutes individuals, not groups or states. In some cases, the office of the prosecutor can open an investigation independent of a referral. However, they must obtain permission from the pre-trial chamber judges before initiating such investigation. After receiving a situation, the prosecutor determines whether the court has jurisdiction in this case. Then they must notify the state parties and other states involved in order to start the investigation. After this, investigators are sent out to collect evidence, and the prosecutor asks for cooperation and assistance from the states and international organizations. After all the investigation, the prosecutor requests the pre-trial chamber to issue an arrest warrant. After arrested, the person is held at the detention center in The Hague, and not long after that, they appear before the court, specifically the pre-trial chamber. Then the process proceeds to the trial chamber, where the prosecution and the counsel for the defense present. After all this comes the judgment and sentencing. The sentence is pronounced in public and maxes out at 30 years in prison. Those who are convicted of their crimes move from the detention center to a prison outside the Netherlands in a state designated by the court. There is an option to appeal the decision if there was a procedural error, new evidence, or old evidence is discovered to be false. In summary, the main objective of the court is to be a last resort option for state governments to indict those who have committed horrible evils. Here are some real-life cases handled by the International Criminal Court. First off is Thomas Lubanga Dilo. Lubanga of the Democratic Republic of Congo was the founder and leader of the Union of the Congolese Patriots, or the UPC for short. He was also a key player in the Ituri conflict. He was the first person convicted by the International Criminal Court. The ICC found him guilty of war crimes, including enlisting and conscripting children under the age of 15 and using them to participate actively in hostilities. The Congolese government referred the situation in April 2004 and thus authorized the investigation and prosecution. Lubanga arrived on March 16, 2006 to The Hague and is currently serving a sentence of 14 years imprisonment. There were some major problems with the trials. Two stick out in particular. First off, human rights groups were concerned with the narrow scope of the charges against Lubanga and wanted the prosecutor to add more crimes to the indictment. There was also an issue with the prosecution obtaining evidence he had received from the United Nations and other sources because of confidentiality reasons. The court ruled that this breached Lubanga's right to a fair trial. The next case is the ongoing trial of Joseph Kony. Perhaps you have heard of Kony 2012. Well, Joseph Kony is the main enemy depicted in the film that went viral back in 2012. Kony was, and still is, rumored to be the leader of the Lord's Resistance Army, or the LRA. He was indicted for both war crimes and crimes against humanity, however, he has not been captured. He is a part of the situation referred to the ICC by the government of Uganda in December 2003. In October of 2005, the ICC announced the arrest warrants for 5 members of the LRA for crimes against humanity. Some of the criminal activities taken into account were enslavement, murder, rape, and enlisting of children. Among these 5 warrants was Joseph Kony. Although there is a warrant out for him, Kony has yet to show his face at the ICC. The situation is full of many of the main current problems with the ICC. The first issue is that there are no enforcement capabilities, so Joseph Kony is still running around as a fugitive. Another issue is that although Uganda enlisted the help of the ICC, they have not been able to follow through on their commitment to cooperation, seeing how Kony is still not captured. Taking all of this into account, it is evident that the ICC is not working as well as it could. Problems that need to be addressed to make the ICC effective are as follows. First off, the ICC needs to promote the involvement of the United States of America, Russia, and China, 3 of the 5 members of the United Nations Security Council. These countries are the most impactful countries in the world currently, and the fact that they are not on board with the International Criminal Court immediately takes away part of the legitimacy of the court. The United States specifically refuses to be involved, claiming that they will not hand over American citizens if they are indicted. Without these major actors, it is hard for the court to be taken seriously on a global level, especially with organizations such as the Security Council also currently in the business of ensuring justice. Secondly, the court needs to issue longer sentences and more consequences. One of the major weaknesses of the court is its inability to issue impactful sentences and consequences. The court has a maximum sentence of 30 years and there is no talk of death penalty ever. These major criminals get let off the hook with minor sentences compared to the gravity of their crime. The third issue with the ICC is the major focus on the African countries. Currently, the court is being criticized for focusing on the crimes of African leaders solely. 100% of the ICC's indictments have been from Africa. However, African countries only make up a little over a quarter of all ICC states. Therefore, the ICC is being accused of selective justice. The last and most impactful problem with the ICC is the lack of enforcement capabilities. Similar to the American three-branch system, the judicial systems are only capable of being maintained if there is an executive branch to execute the court's decisions. The weakest part of the International Criminal Court is the lack of this executing power. Many instances have occurred since the inception of the court where the prosecutor has the evidence, the indictment has been issued, but no trial ensues simply because the indicted is not turned over to the ICC for trial. Therefore, the suspect remains at large as an international criminal. So in conclusion, the International Criminal Court is a great idea. It addresses a major issue, affirming that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. However, even with the Rome Statute and the multitude of states who agree, it lacks major components that would give it the strength and legitimacy to actually have a major impact in the global sphere.